All right, good afternoon. This is the Colorado Oil and Gas Conservation Commission. It is Thursday, March 9th. It is 3 p.m. We have an agendized matter for this meeting. We will start with the roll call.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Ray.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Great. Great to see everybody. We have one matter on our agenda this afternoon. It is docket 2206-00164. This is a matter that we heard a little bit ago, and we have a motion from the applicant for reconsideration of the SUMAC 1265-13 oil and gas development plan. Pursuant to my understanding of the hearing officer order, we're going to hear, we've given the plaintiff or the petitioner 15 minutes to provide a presentation of the motion. We will have commissioner questions and deliberations. We do not have sort of a response from staff on this, and so it's just before the commission. Ms. Wazelinski, good to see you. Does that agenda comport with your understanding of what we're doing this afternoon?
It does. Thank you, Chair.
Very good. Are you ready to go?
I am, yes.
Then you are recognized.
Thank you. And good afternoon, commissioners. Again, my name is Kelsey Wazelinski with Jost Energy Law, and with Jamie Jost, we represent CCRP Operating in the motion for reconsideration before you today in docket 2206-00164. CCRP did not take the filing of this motion lightly. CCRP had several conversations with CPW after the February 15th hearing, reviewed the record and the audio recordings of the 2 hearings on the SUMAC OGDP, and ultimately determined that this motion is both appropriate and necessary under Colorado Rule of Civil Procedure 121, Section 115, Subpart 11, which applies to this motion via Rule 517A. Rule of Civil Procedure 121 provides in part that a party moving to reconsider must show more than a disagreement with the Commission's decision. A motion to reconsider must allege a manifest error of fact or law that clearly mandates a different result. CCRP maintains that the oral order of the Commission at the February 15th hearing denying the SUMAC OGDP is a manifest error of both fact and law that clearly mandates a different result. And CCRP respectfully requests that you grant the motion to reconsider and approve the OGDP based on the record before you and upon finding that the OGDP complies with the Commission's rules and protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Rule 307 outlines the standards for approval and denial of an OGDP. The standard for approval is that the OGDP complies with all requirements of the Commission's rules and protects and minimizes adverse impacts. The standard for denial is that the OGDP does not provide necessary and reasonable protections for or minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, or fails to meet the requirements of the Commission's rules. I stress these words necessary and reasonable because, as I will elaborate on, the record provides substantial evidence that the SUMAC OGDP complies with the rules and the Oil and Gas Act and is protective. Further, there's no evidence in the record that development from an alternative existing location, a location that was not up for review by this commission, is both necessary to protect the wildlife and is reasonable to protect the wildlife. The record extends to all of the facts in this case, which are not limited to the presentations and testimony provided at the February hearings, but also include the following: evidence of a Weld County pre-application consultation, which COGCC was a referral agency to, in February of 2022. This was 1 year prior to the OGDP coming before the Commission and over 4 months prior to CCRP filing the OGDP application in June, during which CPW and COGCC staff discussed the SUMAC location and 3 potential alternatives. During this meeting, neither CPW nor COGCC staff expressed any reason not to pursue the SUMAC location. This consultation summary is attached to the Form 2A. I will note that the statement of basis and purpose for Rule 301 F4C states that the intent of a referral agency pre-application consultation is to identify potential issues that might arise if an operator proposed the oil and gas location subject to the local government permitting process, to avoid the undesirable and unlikely outcome of an operator receiving siting approval from the local government, but not receiving approval for the same location from the commission. The record also includes evidence of an on-site consultation in March of 2022 with CCRP and CPW staff, which is over 3 months prior to CCRP filing the OGDP application, during which the proposed sumac location, alternative locations, and site-specific mitigation measures were discussed to protect the wintering big game. Again, CPW did not express any reason not to pursue the sumac location at the on-site consultation. And the result of that consultation was that CPW and CCRP discussed appropriate compensatory mitigation dollar amounts for developing inside and outside of the winter season. This consultation summary is also attached to the Form 2A. Evidence of a wildlife mitigation plan that was developed in consultation with CPW, including compensatory mitigation, BMPs, and timing stipulations agreed upon by CPW to protect the HPH. In addition, the wildlife mitigation plan, the sumac location Form 2A contains 13 additional site-specific plans, a detailed alternative location analysis, and as I mentioned, Weld County and CPW consultation summaries. Evidence of an approved 1041 WOGLA permit, a vested property right that resulted from a robust Weld County 1041 siting process. And finally, evidence of the director's recommendation of conditional approval of the uncontested sumac OGDP and CCRP's agreement with all 3 of the conditions outlined in the director's recommendation. And these conditions would include the modified condition of approval agreed to by CCRP at the February 15th hearing that the existing Grindberg location be reclaimed by a date certain and not used for saltwater disposal. I highlight the substantial record in this matter because the commissioner's deliberations at the February 15th hearing did not take this record into account. Instead, a singular statement by COGCC engineering manager Diana Byrne that step-outs needed to reach the eastern minerals in the proposed unit are common in the core of the DJ Basin, which is not the most northern part of the DJ Basin and state of Colorado where the sumac location is located, was relied upon by at least 3 commissioners to conclude that drilling the proposed unit from an existing location is technically feasible, and therefore it would be more protective of wildlife as compared to the proposed location. In fact, based on the public records of the COGCC, only 29 of the over 8,200 wells in the core of the DJ have a step out equal to or greater than the 3,960-foot step out required from the Grindberg location to the easternmost sumac well. That is less than 0.4% of wells in the core of the DJ. This singular statement, without any evidence or testimony in support, serves as the first point of error in fact and law for the commissioner's decision on CCRP's OGDP. The commission's rules and the Oil and Gas Act do not provide a process by which the commission can elevate an allegedly more protective location over the proposed sumac location without analyzing that alternative through the necessary and reasonable lens. Both of those standards must be met in order for the commission to deny the OGDP. And this leads to the second error of fact and law, which is the commission's failure to apply the legal standard required to deny an OGDP. And that requires a finding based on the facts in the record that the OGDP does not provide both necessary and reasonable protections for or minimize adverse impacts to the HPH. Both the Act and the rules define minimize adverse impacts as to the extent necessary and reasonable to protect wildlife. So the questions that the commission failed to ask were, first, is it necessary to develop the proposed minerals from an existing location to protect wildlife? The record shows that it is not. CPW concluded both in its written wildlife assessment and during testimony at the February 15th hearing that the sumac location is protective of the HPH. CPW's expertise on this matter must be given the appropriate weight. And second, is it also reasonable to develop the proposed minerals from an existing location to protect wildlife? The record also shows that it is not. The sumac location complies with the commission's rules and protects and minimizes adverse impacts to wildlife through agreed upon BMPs, timing stipulations, and the payment of compensatory mitigation. and CCRP testified that it would not fully develop the targeted minerals from an existing location due to significant well failures that would result, thereby leaving the easternmost hydrocarbons undeveloped and creating waste. The third error of fact and law is the Commission's misapplication of the role of alternative location analysis. I want to take a moment to highlight the record associated with the ALA and consultation processes for the Sumac OGDP, which were robust and appropriate. Before CCRP filed the 1041 WOGLA permit and the OGDP application, CCRP consulted with Weld County, COGCC staff, and CPW to discuss the preferred location and 3 alternative locations. And I stress again that no concerns about the Sumac location were raised by CPW or COGCC staff during the pre-application consultations. At the February 2022 consultation with CPW, the technical subsurface constraints associated with drilling from the existing Grindberg and True Ranch locations were discussed, and CCRP explained its reasoning why the Sumac location is the preferred location. Again, the CPW consultation summaries are in the record on the Form 2A. In the 1 year between the initial consultations with COGCC and CPW staff and the hearing date, Rule 309E allows CPW to make written recommendations to the director, including a recommendation that the Commission deny an OGDP, Form 2A, or wildlife mitigation plan due to reasonably foreseeable risks or adverse impacts to wildlife resources that cannot be avoided, minimized, or mitigated to the extent necessary to protect these resources from oil and gas operations. But CPW did not recommend denial of the OGDP. Instead, because it is not possible to avoid the HPH entirely, CPW worked with CCRP under the rules and processes established by Rules 1202D and 1203 to develop a wildlife mitigation plan with compensatory mitigation to protect the HPH, which CPW approved. As you consider CCRP's motion and the standards of approval for an OGDP, it is important to recognize that the Commission's consultation and wildlife rules highlight CPW's expertise in the area of wildlife and habitat management. CCRP acknowledges the written statement from CPW, issued just 15 days before the February 1st hearing, that CPW may prefer the use of existing locations based on CPW's goal to have operators co-locate new locations to the extent possible to minimize the fragmentation of sensitive habitats. But the more important piece of this written statement and the ultimate conclusion by CPW is that the Sumac location is protective of the HPH. And this statement, that the Sumac location is protective, is the critical conclusion of the wildlife expert and the result of CPW's authority to consult on a proposed location under the Commission's rules. The Commission must also acknowledge that CPW is not a subsurface expert. CPW's goal is to protect wildlife, which it has done in this instance. On the subsurface constraints associated with the alternative locations, CCRP presented testimony at the hearings in February regarding why it is not possible for CCRP to fully develop the proposed unit from an existing location. CCRP's operations manager, Nathan Korzewski, testified that based on very similar step-out distances drilled close to the Sumac pad, wells with longer step-outs have more incremental well failures over the life of the well. CCRP's Vice President of Land, Jesse Martin, testified that CCRP would not drill the easternmost unit wells from the existing Grindberg location due to the step-out risk required, and would not drill even more wells from the existing True Ranch location due to an even longer step-out distance required. You also heard testimony from Ken Cooper, Managing Principal at Petrotech Engineering, that this area of Weld County near the Wyoming border is far from the core of the DJ Basin. It is different rock with different recovery factors and much different economics. You simply cannot compare horizontal development and step-out capabilities in the core of the DJ to this area of Colorado. I'm now just going to ask Ms. Jost to please share her screen with a short PowerPoint to summarize and conclude CCRP's positions. Based on the substantial record before you, the oral order denying the Sumac OGDP was based on several manifest errors of both fact and law, and these are as follows. First, the Commission relied on a statement from Ms. Byrne that step-out distances needed to reach the eastern part of the unit are common in the core of the DJ to conclude that developing the proposed unit from an existing location is feasible and therefore more protective of the HPH. This is an error of fact because development and step-out distances in the core of the DJ cannot be compared to development and step-out distances far outside of the core in northern Weld County. This is an error of fact because public COGCC records show that less than 0.4% of wells in the core of the DJ have a step-out equal to or greater than what would be required to reach the easternmost sumac well from the Greinberg location, and therefore 3,900-foot step-outs are not in fact common. This is an error of law because neither the rules nor the act create a mechanism by which an allegedly more protective location be analyzed against the proposed location before you find that use of an alternative location is both necessary and reasonable to protect the HPH. The commission did not meet the legal standard required to deny the OGDP. Next slide. Second, the commission cited the mitigation hierarchy of avoid first, then minimize, then mitigate to conclude that CCRP is not avoiding impacts first by using an existing location. This is an error of fact because the records of the OGDP show that HPH cannot be avoided to develop the targeted minerals. Because impacts are unavoidable, CCRP, in consultation with CPW, developed a wildlife mitigation plan and agreed to compensatory mitigation to minimize and mitigate adverse impacts to HPH pursuant to rules 1202D and 1203. This is an error of law because the analysis fails to include whether use of an alternative location is both necessary and reasonable to protect the wildlife, and the commission did not meet the legal standard required to deny the OGDP. Next slide. And third, the commission stated that the role of ALA is to present the best location, and the alleged inconvenience of developing from an alternative is not a sufficient reason to not pursue the best location. This is an error of fact because the consultation summaries and ALA narratives on the Form 2A and testimony of CCRP show that CCRP cannot and will not develop the entirety of the proposed unit from an existing location. This is an error of law because denying an OGDP on the basis that it is not the best location as compared to an alternative must be based on a finding that the use of an alternative is both necessary and reasonable to protect the wildlife, and the commission did not meet this legal standard. Next slide. The rules in the act are very intentional in defining the standard of approval of an OGDP. Chair Robbins and Commissioner Cross acknowledged in their deliberations and votes to approve the OGDP that the sumac location avoids all but one ALA criteria, being the wintering big game habitats, and that the commission's job is not to look at better locations, but to look at the location proposed and to determine if it meets COGCC rules. And because avoidance of HPH cannot occur, then CCRP must minimize and mitigate in a necessary and reasonable manner, and CCRP meets this legal standard. However, the precedent set by the denial of the sumac OGDP is that a location can comply with the rules, can come to the commission uncontested on a director recommendation of approval with an approved 1041 WOGLA permit after a year's worth of engagement with Weld County, the COGCC, and CPW, can have protective site-specific BMPs, timing stipulations to avoid operations in the winter season, and payment of compensatory mitigation, and be denied because an alternative existing location could allegedly be more protective of wildlife, but without finding that use of an existing location is both necessary and reasonable to protect the HPH. And for these reasons, we respectfully request that you grant the motion, and based on the record in this matter and the applicable legal standards, you approve the sumac OGDP because it complies with all requirements of the rules and the act and protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Thank you for your time hearing this motion today. Mr. Martin and Mr. Korzewski are in attendance, and we are happy to answer any questions you may have.
Okay, thank you very much. Commissioners, normally in a court of law, when a judge hears a motion for reconsideration, it takes it up on the written briefs and it also takes it up on the oral argument. It is rare that a commission would reopen the record to introduce additional evidence, which would be the case if we were to ask Mr. Martin or Mr. Korzewski questions. So I caution you ahead of our questions for Ms. Wazelinski, as well as deliberations on the motion, that we need to be careful in terms of not reopening the record absent extraordinary circumstances. With that cautionary tale, I would see if anyone has questions for the attorney, Ms. Wozlinski, and her presentation. Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Ms. Wozlinski, for your follow-up today. And I have said to Commissioner Robbins more than once, sometimes I wish I had a law degree, and many times I'm very happy that I don't. So I am wondering if you could explain a little bit, as a commissioner, as we're trying to weigh the hierarchy of avoid, minimize, and mitigate with the alternative location analysis and necessary and reasonable, whether those weigh equally or they're different. And I'm not sure that that's kind of addressed here versus I feel like in your presentation, your weight is on the necessary and reasonable over the avoid, minimize, and mitigate.
And thank you for that question. It's a good one. And the reason we focus on necessary and reasonable is because that's the legal standard to deny an OGDP. And minimize and mitigate is also tied to a necessary and reasonable standard. So the legal standard for you to deny sumac because allegedly another location may be more protective has to be based on that it's necessary to protect the wildlife, and it's also reasonable to protect the wildlife. So that's the legal standard. In terms of avoid, minimize, and mitigate, I think that hierarchy is made very clear both in the rules and then in the statement of basis and purpose. And in this instance, HPH cannot be avoided. You can't entirely avoid impacts because you can't access the minerals outside of HPH. And so then you move to minimize and mitigate. And under the rules 1202D and 1203, CCRP engaged in consultation, did compensatory mitigation, and has a wildlife mitigation plan to meet those requirements.
Thank you. So I think what I hear you saying is, regardless of the location that's chosen, whether it's the Greenberg or the sumac, there are high priority habitat impacts. I think so given that, I'm also considering the avoid first, then minimize, then mitigate. And it seems that there would be less of an impact at the Greenberg location. So then I go to the second, that for me, the second layer, which is, so what are the implications of that other location? And I read in your, I don't know what you submitted back to us, I'm sorry, that part of the consideration is the full development of the unit. But I think that when we discussed this issue overall, the unit is not being fully developed anyway, even if it were to be developed from the sumac location. And so do you agree that either way, there isn't full development of the minerals in that unit?
I would respectfully not agree with that. We had a long discussion on correlative rights, and it was a good discussion. And we had testimony from Petrotech on why 4 wells will sufficiently develop and adequately drain the unit while preventing waste and protecting correlative rights. And CCRP will stand by that 4-well density as the efficient development plan. So no, I don't think that hydrocarbons are being left in the ground with a 4-well development plan. If I may, I just want to clarify, a lot of the discussion in the February hearings and what was raised in our motion was the role of alternative location analysis. And that really occurs at the outset of an OGDP and in tandem with consultation. And before you file, you're using ALA, and CCRP used ALA to choose a preferred location, but also while evaluating alternatives, and to have that discussion before filing, because if big red flags are raised, perhaps you don't move forward with a preferred location. And in this instance, that didn't happen. And I think when you compare impacts and say, well, maybe it's more protective from Grindberg, the role of ALA is not to have 4 Form 2As and say, here's a preferred Form 2A and here's 3 other Form 2As, and we're going to file all 4 of them, and then we're going to take it up to the commission, and then you can decide what's most protective. That's not how the rules work. That's not how the process works. There's a preferred location. It's the permit applied for. It's the permit in front of the commission. And in order to deny that permit, you have to find that it's not only necessary to protect the wildlife, but also reasonable, which is why we keep going back to the legal standard for approval and denial. Because, based on the facts in the record and CPW's positions on this, because sumac is protective, you don't meet that legal standard.
I've been thinking about that, and kind of the fact that we put Mr. Moret kind of in the hot spot, because the discussion and I think the proposal changed a little bit from the original, what had been submitted and what he had given his thoughts about, or his consultation about, right? And I think probably also, there's been a lot of discussion about whether or not it is technically feasible to develop from the Grindberg location. And then after he heard that discussion and the commissioners kind of digging into, can you do a step out that far or can you not? I think then his thoughts about what might be reasonable then changed based on, is that other location feasible or not? Because I think when he did his original consultation, he did not think the Grindberg was a feasible or technically feasible location. And therefore his reasonable and necessariness is based on what the evidence was in front of him at that point in time with alternative location analysis.
Sure, and I want to be very careful. I do not want to speak for Mr. Moret or CPW, but based on the record, I don't think CPW's position changed. I think there was pre-application consultation where alternatives and a preferred were discussed, and no statement by CPW during those initial consultations led CCRP to say we're not going to move forward with sumac. And that's evidenced in a wildlife mitigation plan with compensatory mitigation that's agreed upon. And CCRP had a right under Rule 309 to recommend denial if CPW, excuse me, I said CCRP, CPW had a right to recommend denial if CPW thinks that impacts can't be avoided, and they didn't recommend denial. They did provide an assessment, and we're not ignoring the fact that they prefer the use of existing, but what's really critical in that assessment is that if the commission moves forward with sumac, it is protective of wildlife. So it again takes us to the necessary and reasonable standard, and you don't meet that standard when you have a location that's protective.
I appreciate you answering my questions. Thank you.
Questions, Commissioner Ackerman?
Thank you, Mr. Chair, and thank you, Ms. Wazelinki, for being here. I just have a couple of clarifying questions associated with your testimony today. And one of those is—
Let me refrain. Her argument is not testimony, just so the record is clear. She provided legal argument. I just don't want to get us mixed up. So thanks, Commissioner Ackerman.
And thank you, Mr. Chair, for fixing my statement. I appreciate that and recognize your correction. With regard to the assertion that the commission relied upon a singular global staff statement on the technical feasibility of step out lengths, my recollection is that upon being asked the direct question to the operator why those step outs were not feasible, I believe it was Mr. Kraszewski, stated that he wasn't saying it's not technically feasible, but rather that there were simply more complications associated with that approach that made it undesirable to the operator and potentially impactful to wildlife due to increased presumed workover traffic. And so how do we rectify those two things? If you're asserting Ms. Burns' statement was in error, are you also asserting that the operator's statement was in error?
Thank you, Commissioner, and I'm not. I think what's important coupled with that statement is the statement of Mr. Jesse Martin saying that CCRP wouldn't take that risk and would not drill those easternmost wells because of the well failure risk. And that's in the record as well during his testimony. And so if CCRP is not going to take that risk and not going to have those additional impacts from that large step out, then you are leaving hydrocarbons in the ground in that easternmost part of the unit, only to be accessed with another surface disturbance.
Thanks for your response there. My second question is with regard to, as I understand your testimony, your interpretation regarding avoid, minimize, mitigate hierarchy is that it's applied to the HPH segment as a whole. So i.e., if one cannot develop outside of an HPH, then the mitigation hierarchy of avoidance and minimization to avoid inverse impacts to wildlife within that HPH block then becomes defunct or is not necessary?
No, I don't think that's the case. There is a defined term in the 1200 series on unavoidable adverse impacts, and that's what kicks off compensatory mitigation. And so this is a situation where you cannot avoid the wildlife because you cannot cite a location outside of HPH, but you can certainly minimize your impacts and then you can mitigate those impacts. And so when we look at the avoid, minimize, mitigate hierarchy, particularly in the context of a defined term tied to wildlife of unavoidable adverse impacts, which then triggers compensatory mitigation, the rules are designed to acknowledge that in some cases you can't avoid wildlife, the 1202D habitats, but you can operate protectively in them with minimization of impacts and mitigation. And here CCRP has timing stipulations, so they will not operate in the winter months. And they also have BMPs, and they also have compensatory mitigation.
All right, thank you. That's all, Mr. Chair, thank you.
Commissioner Messner.
Thank you, Mr. Chair. I wanted to go a little further on this because I've read your argument and listened to your argument today. And it also appears to me that you're arguing that somewhere in the rules it indicates that the avoid, minimize, and mitigate strategy only applies to high priority habitats as a whole. And so I'm trying to ask where in the rules you're seeing that, because that's not, I've not been able to find that in the rules.
And I'm not sure I'm classifying it that way. I think what's really critical here is that if you are going to deny a location, which you've done via oral order, in order to meet that legal standard, you need to find that it's both necessary and reasonable to protect the wildlife. And so I will maintain that this location does meet the mitigation hierarchy, and it meets the intent of the rules in the Act by minimizing and mitigating unavoidable adverse impacts. And
But do you acknowledge, though, that the Act, the rules, the statement of basis and purpose talks about avoiding adverse impact to wildlife resources? So it's not specific to wildlife. It's not specific to high priority habitat. It is specific to adverse impacts.
Mhm.
And it is specific to wildlife resources, which is a broad category of things that could include resources both inside of a high priority habitat and not just avoiding the high priority habitat itself. And so it is possible that you could avoid adverse impacts to wildlife resources within a high priority habitat by site location.
I understand your analysis. I would also say that timing stipulations are another way to address those impacts. And I hesitate to say avoid, because I think the rules are constructed in a way to acknowledge that in 1202D habitats, you can't avoid all impacts. Even if CCRP were to use an existing location, the Grindberg location, they can't avoid impact to wildlife because they're in defined HPH.
It's wildlife resources, which means, and this is the definition from the 100 series, fish, wildlife, and their aquatic and terrestrial habitats used for all life stages, including reproduction, rearing of young and foraging, and the migration corridors and seasonal ranges necessary to sustain robust wildlife populations. And so site selection and choosing disturbance levels of sites is directly related to avoiding adverse impacts to wildlife resources.
Sure, and I won't argue with you on that. I think, again, the role of that analysis is at the outset of a permit and trying to choose a location that is protective and that meets the requirements of the rules. But ultimately, an operator has to come forward with one Form 2A, in this case, the sumac location. And it's the commission's role to evaluate that Form 2A and does it comply with the act and our rules? And I think here, again, if you're going to deny it because there's an argument that it would be more protective from another location, it has to be both necessary and reasonable. And that's why we stress this so much, because the commission didn't meet that standard when you have a CPW acknowledging that the location is protective and you've got a fairly large record that it's a protective location.
So let me just ask you one last question here. Does that pre-application meeting that is included in the rules supplant the OGDP hearing in the commission's jurisdiction to determine whether an application is protective of public health, safety, welfare, the environment, and wildlife resources?
It does not.
Okay, thank you.
Further questions of the attorney? Okay, seeing no further questions, Ms. Wasilinski, appreciate your presentation this afternoon. We will move into a deliberation stage. Is everybody ready to move into deliberations at this point? Okay. It might be appropriate then to look to deliberations from our commissioners. Commissioner Ackerman, I think it is appropriate that you go first.
Thank you, Mr. Chair. I will jump in. I appreciate that. I wanted to thank Ms. Wasilinski for her articulate and respectful presentation and appreciate her appearing before us today. I do have some thoughts on this, and they are similar. I've expressed most of them in previous testimony, but with regard to argument number one, that the commission cannot deny a location based on a more protective alternative, I think this is a great point. I'm glad we're talking about it. And although there was much focus on the Grindberg pad alternative during our testimony and our hearings, I, as one commissioner, did not randomly consider Grindberg as a location I just thought would be more protective than the proposed location. Rather, the Grindberg pad was considered and dismissed by the operator during the alternative location analysis process, which must be evaluated during the commission process. And as has been testified in the 100 series definitions, avoid adverse impacts means to deferentially select alternative locations, practices, or methods for oil and gas operations based on site-specific circumstances so that those operations will not cause quantifiable direct, indirect, or cumulative adverse impacts to the potentially affected resources. Similarly, unavoidable adverse impacts means direct, indirect, or cumulative adverse impacts to public health, safety, welfare, the environment, or wildlife resources that are not entirely eliminated through the application of alternative location selection or other methods designed to minimize adverse impacts. So the regulations and the ALA basis and purpose statement clearly set forth that an applicant must consider and attempt to abate potential adverse impacts through the selection of the best surface location, as Ms. Wasilinski informed us. Thank you. They bring forth one 2A, and we expect that 2A will be the most appropriate 2A. In this case, I disagree that the 2A that was brought forth was the most appropriate, which is clearly within the evaluative criteria that the commission afford to applications. The operator argued that the potential increase in truck trips associated with step outs on the Grindberg pad would be detrimental to wildlife, and that's true. Most development of any kind can be detrimental to wildlife. But the argument that the ALA dismissal relied upon, that the resulting 2 increased truck trips per month over the life of a well to a location alongside an already disturbed county road is worse for the environment than all of the traffic to an entirely new location in relatively undisturbed habitat, along with its 3/4-mile spur road and all of the attenuating construction, pre-production, and oil transport truck trips, as there is no pipeline takeaway, just simply falls flat to me as a reason to discount that site in the ALA. With regard to argument number 2, the commission's finding that the application did not adequately avoid, minimize, and mitigate wildlife is contrary to the record. So notwithstanding the points I just discussed about the ALA and the Grindberg pad, using another ALA proposed location is really simply peripheral and supplementary to my primary reason for voting to deny the application, which was that the application did not meet the commission's requirements of adhering to the mitigation hierarchy. So the entire intent of the mitigation hierarchy is to protect wildlife. And the mitigation hierarchy does allow for development in HPH if impacts cannot be otherwise avoided or minimized. It doesn't specifically tie that to HPH blocks, but rather in HPH in general, meaning, as Commissioner Messner so astutely pointed out, that impacts within HPH also fall within this definition, in my opinion. So, and when a protective mitigation plan can be devised, as they did. The hierarchy states that avoidance of impacts should first be employed, minimization is next, and mitigation is a last resort. And there's a reason for that approach. It's not the intent of the commission to create an either or pay-to-play program that allows development in HPH, so long as an operator is willing to pay mitigation fees. Rather, the hierarchy requires that if there is a more protective alternative that avoids and or minimizes, it must be considered and employed before taking a mitigation approach, with mitigation only intended to address those impacts that are left over, that cannot be avoided or minimized. So the operator argued that it worked with CPW to devise and propose a mitigation plan that was sufficiently protective of wildlife. And I would hope so. That's exactly what a mitigation plan is intended to do, as the mitigation portion of the hierarchy is intentionally set up to attempt to be sufficiently protective of wildlife. What's missing from that argument is that the mitigation portion of the hierarchy is intentionally set up to attempt to be sufficiently protective of wildlife in the event that mitigation is necessary due to residual impacts after all we can do to avoid and minimize impacts. So what we heard in testimony from the operator was that a different location proposed and dismissed by the operator in conducting its ALA, the Grindberg. I heard that it was technically feasible, but that it was not preferred due to longer step outs. And I heard that it was technically feasible from the operator as well as staff. CPW testified verbally and in writing that the sumac pad was clearly the least preferable alternative, but that the operator said that other locations were not technically feasible due to those step outs. And so this is a really important point. CPW is not an expert in technical feasibility of drilling and production operations, as Ms. Wazaliki pointed out, and therefore helped the operator prepare a mitigation plan consistent with the operator's wishes, not knowing if CPW's preferred approach using a nearby existing pad would even be viable. This is exactly what CPW should do in order to protect wildlife, but it doesn't constitute an explicit or tacit endorsement that that approach is their preferred approach or is the most protective of wildlife. Rather, CPW counts on us to do our job properly, to employ the mitigation hierarchy, and then it plans with the operator for protection on each level of that hierarchy as best it can and as is appropriate in the mitigation hierarchy. So with regard to that point, and this is largely what my decision was based upon when I voted to not deny the application, is that the record clearly states CPW's preference that the sumac pad was the least desirable option if other less intrusive options were feasible. And the record also clearly states that there's a technically feasible location, though not preferred by the operator, that was considered during the ALA process, a process that is specifically intended to determine the best location for a given development. Addressing wildlife impacts associated with the sumac pad are technically feasible at the avoidance and minimization levels if the operator properly employed the ALA process to select the most protective location for the development. So in the end, my opinion is that this scenario is a clear example of why the technical and economic feasibility exception was removed from the statute in favor of the more protective approach, instead mandating reasonable and necessary strategies to protect wildlife. And in this case, I think the standard was met that it is reasonable to be able to develop from a technically feasible location that is much more protective of wildlife, as stated by CPW. As such, in my opinion, the commission's ruling was and is consistent with the spirit and letter of the law of Senate Bill 181, as well as our regulations. And the argument in this case that the specific measure to use a feasible, more protective location proposed and dismissed by the operator in its ALA is not reasonable and necessary to protect wildlife, to me is tantamount to an argument that the mitigation hierarchy is not reasonable and necessary to protect wildlife. The commission has allowed development in HPH because it has made a good faith effort to employ the mitigation hierarchy as intended. And this commissioner expects operators to employ the same good faith effort from their end and utilize technically feasible solutions to the extent that it can protect wildlife. With regard to the argument associated with waste, the operator argued that prohibiting development from its proposed sumac pad constitute waste as it wouldn't develop the easternmost reach of the development except from the sumac pad. The record contains expert staff testimony and operator testimony that reaching the easternmost portion is technically feasible from an existing pad. The record does state that the operator would choose, as Ms. Wazelinski pointed out, not to employ that technical solution if required to do so from the existing pad. And CRS 346103 says waste does not include the non-production of oil and gas from a formation if necessary to protect public health, safety, welfare, the environment, or wildlife resources as determined by the commission. So my opinion on that point is as follows. Denial of this application based on the operator's failure to properly, in my opinion, follow the mitigation hierarchy makes this waste issue in and of itself irrelevant. Nevertheless, the record clearly shows that the operator could develop the resource from an existing pad, removing the argument that the commission is causing waste rather than the operator choosing not to develop. But even so, I would assert that the choice of an operator not to develop a resource also does not prima facie constitute waste. So, Mr. Chair, I believe that the commission acted in good faith. I believe that its decision was based on appropriate evidence presented in the record and appropriate testimony presented in the record and appropriate interpretation of Senate Bill 181 and existing regulations. Thanks.
Thank you, Commissioner Ackerman, for your well-articulated thoughts, deliberative thoughts on this matter. I'll join you a bit. It's interesting because I want to first note that the standard for the commission should only grant the commission to reconsider if it finds that there has been a manifest error of fact or law that clearly mandates a different result or other circumstance resulting in manifest injustice. Now, I would note I was in the minority and voted to approve this OGTP, but the standard here is a much higher and more deferential one than what was applied to our vote to approve or deny. I went back and revisited by listening into our deliberations from February 15th to determine whether I think there was a manifest error in the decision to deny the SUMAC OGTP. As you have articulated, Commissioner Ackerman, I believe that the commissioners that voted to deny the application met our rules, and I do not believe that that denial can be overturned on a motion to consider today. And I believe that while I was in the minority, that this commission appropriately utilized the alternative location analysis. And I want to expand on that a bit because I don't want there to be precedential value associated with this. This was decided based upon the specific instances of this application. The purpose of the ALA is for the operator to ensure that they have considered potential adverse impacts in selecting the best surface location, and informs the operator which location to move forward with the application. Staff and the commission should then review the ALA to inform their determination on whether the proposed location, here the SUMAC, complies with the Act and rules. Here, commissioners reviewed the ALA and determined that based upon the opportunity to use an existing location to avoid or minimize impacts to wildlife, SUMAC did not comply with the Act and rules. Now, I didn't agree with that, but I'm looking at it from the lens of a motion to reconsider. So the finding was specific to the proposed location, whether the SUMAC location complied with the Act and our rules. Here, the finding was that it did not, because it did not avoid wildlife impacts and thus did not comply with the rule concerning minimizing adverse impacts. It is influential to the decision that the Grenberg pad was an ALA location that could avoid wildlife and also reach the mineral resource. And I agree with you, Commissioner Ackerman, in your recitation of the facts that were before us, that it wasn't a singular instance of Ms. Byrne testifying, but it was also the applicant who also testified that Grinberg was technically feasible, although they preferred not to use it. For these reasons, I do not find that the commission committed a manifest error of fact or law in denying the Sumac OGDP. I would like to emphasize that my conclusion is specific to these circumstances and the application of the legal requirements I just discussed. I do not want to suggest that it is permissible for the commission to deny a proposed location because we just happen to like another location better. If that was the sole basis for the commission's decision to deny the OGDP, I would likely come to a different conclusion based upon this motion to consider. It is the commission's responsibility in the end to review every application, including an ALA, to determine whether the location that the operator has proposed complies with the act. We are not allowed, in my opinion, to reject a proposed location that otherwise meets these standards just because we believe another location could be more protective. However, my review of the record is that's not what happened here. Again, the determination from the 3 denial commissioners was that the Sumac did not meet our rules and regulations. For these reasons, I would not determine that manifest error of fact or law occurred, and I would not be in favor of approving the motion for reconsideration. Commissioner Cross.
Thank you, Mr. Chair, and thank you, Ms. Wesselinski, for coming before us today. And thank you, Commissioner Ackerman, for leading off there. I'm going to go through a few things and then I'll explain my reasoning, which I think should sound somewhat similar. I'd like to start off specifically looking at the definitions of avoiding adverse impacts in both the statute and in our regulations. And when you look at the statute, CRS 3460-103 5.5 says, you minimize adverse impacts means to the extent necessary and reasonable to protect public health, safety, and welfare, the environment and wildlife resources, to A, avoid adverse impacts from oil and gas operations, and B, minimize and mitigate the extent and severity of those impacts that cannot be avoided. And as Commissioner Messner mentioned in his questioning, wildlife resources in the statute is defined as fish, wildlife, and their aquatic and terrestrial habitats. Similarly, when you go into the actual, let me pull it up here, into the regulations as well, when you look at avoiding adverse impacts, it means to differentially select alternative locations, practices, or methods for oil and gas operations based on site-specific circumstances so that those operations will not cause quantifiable direct, indirect, or cumulative adverse impacts to the potentially affected resource or resources. When you look at unavoidable impacts, and I think that's key here, so I get down to it, I want to make sure I read it verbatim. Unavoidable adverse impacts means direct, indirect, or cumulative adverse impacts to public health, safety, welfare, the environment, or wildlife resources that are not entirely eliminated through the application of alternative location selection or other methods designed to minimize adverse impacts from oil and gas operations. And I think that entirely is a very important part. When you look at the situation we're facing here, both the Greinberg and the Sumac location are both within high priority habitat. And I fully understand what Commissioner Ackerman and Commissioner Messner have argued here, that even within that high priority habitat, there are still wildlife resources, whether it be the fish, aquatic species, the terrestrial habitats, or the animals and their terrestrial habitats can still be affected. And you're looking at whether you avoid, minimize, and mitigate the impacts to them. And I think the key thing that is missing from some of the discussion, in my opinion, is that in the original hearing, nothing said that the Greinberg location versus the Sumac location would entirely eliminate any adverse impacts to wildlife resources. And I think that is critical, because without entirely eliminating the adverse impacts, the next step is to minimize and mitigate the impacts to wildlife resources. And based on the testimony that was provided, in my opinion, what was presented to the commission was CPW saying, in consultation with the operator and based on what staff had said, the wildlife mitigation plan was sufficient to adequately protect through minimization and mitigation procedures adverse impacts to wildlife resources. And so I wanted to clarify that first with what I was specifically looking at in the initial hearing. It's not a matter of saying we first must avoid, minimize, then mitigate. I agree with that. I agree that that's what the hierarchy requires. I agree that that's what is required by our statute and our regulations as written. And I think the key thing, especially as we move forward, is that if you're going to continue to look at avoiding, you have to look at avoiding all of the adverse impacts. And nothing in my mind was shown to entirely avoid the adverse impacts, which is what our definitions and our regulations specifically say. And I want to go into a little bit with respect to what Commissioner Ackerman said there as well. Our job as a commission is not to pick the most appropriate location. Our job is to look at what is presented to us and see if the location and the application before us meets the regulations. We have these stringent regulations, and if those regulations are met, then we can approve the application. And as I said during the initial hearing, I think that the application presented by CCRP, because nothing showed that adverse impacts could be entirely eliminated, minimization and mitigation was appropriate, and therefore the sumac location as proposed met. Now, that's not to say that I think that it was the best location, because I don't think it was the best location. I think it would be better to have the Grindberg location. But my job as commissioner and looking at what was proposed before us, I do think met the rules. And I also want to highlight one other thing that Commissioner Ackerman said, and I don't think it's our job to say CPW would prefer another location and therefore we should choose the other location. I think it's still under our purview to say, based on what was reviewed, based on what was selected, did CPW in its consultation determine that this was sufficiently protective, whether through avoidance or through minimization and mitigation? And so I just want to make those couple clarifying points. That said, I agree with Chair Robbins. We're under a very different, this is not just simply a rehearing and we're looking at this again. We're looking at this based on, was there manifest error? And I don't think, based on the decisions rendered by my fellow commissioners, there was a manifest error. I think it's important to note that there will be differing views on how the avoid, minimize, and mitigate works and how it's applied. I want to emphasize that I do think that the application could not avoid and therefore went to minimize and mitigate. But looking at the deliberations and the decisions made by my fellow commissioners, I do not see any manifest error in their decision with respect to why they did not believe that this application did not appropriately minimize or avoid, then minimize and mitigate adverse impacts. And I'll make one final comment with respect to the waste issue. And I don't want to go into depth about what staff said, what Ms. Burns said versus what the engineer said for CCRP about whether it would be able to do it. I still inherently do have some questions on whether the frac wing on 4 wells within a 1260 is going to completely drain. But I also do agree, as I stated during the first hearing, that the goal should not be to try and permit as many wells as possible. Instead, it's appropriate to make sure that we are looking at what is reasonable based on what the operator is looking to do. And knowing that the mineral owners, the interest owners, are aware of what's happening. And so they're not arguing that there's any waste here. But one thing that I think is important is the idea that there's going to be waste created because of not drilling the far east well in this. And I think one clarifying point that is important to me is if we were looking at this under a different situation where I agree with Commissioner Ackerman and Chair Robbins about the feasibility aspect, because it was not just Ms. Byrne, our engineering manager, that specifically stated that it was feasible, but also engineering testimony from the applicant said it is feasible, though not preferred. And so I think one of the key things for me looking forward is that if this situation were to occur, it's not simply a matter of, well, now we have waste because the entire 1260 is not being developed. If you're not going to be developing the 1260 because you're saying you're not going to develop it, I'm going to want that DSU changed. And I'm going to want a DSU that is going to appropriately be developed by that. And so don't say, well, we're doing a 1260 and under what we want to do, we're going to have waste because of that. And so therefore you have to pass it. Instead, come up with a DSU that if really all you're going to do is those 3 wells, tell me we want a DSU for the area that's going to be covered by those 3 wells. And because of that, because of the ability to change a DSU, I don't think that that's waste either. So I'll conclude just by saying that I do believe that my initial decision in this hearing was correct, but we're not simply rehearing the decisions that were made before. We're reconsidering based on a challenge of whether this was manifest error of fact or law. And I don't believe that my fellow commissioners that voted to deny this application did have a manifest error of fact or law.
Commissioner Messner.
Thank you, Mr. Chair, and thank you to Chair Robbins and Commissioner Ackerman and Commissioner Cross for your thoughts on this, and I appreciate it. I'm not going to go into a bunch of detail on the merits of the initial application. I think that what we're being asked today is whether or not we made a manifest error of fact or law that clearly mandates a different result than the result that we came up with in the initial hearing. I mean, I would love to argue with you, Commissioner Cross, about interpretation of ALAs and the mitigation hierarchy, because I disagree with you quite a bit on your interpretation of that in order to avoid, you would have to avoid all adverse impacts in entirety before you apply the minimize and mitigation strategy. I think that's too broad of an interpretation of what that particular piece of the act indicates. What I read that as is that they're even in an avoidance strategy, let's say you avoid 95% of adverse impacts associated to wildlife resources, there still may be 5% that you may need to apply the minimization and mitigation strategies to, because there is a wide array of potential impacts that could be associated to wildlife resources and the different elements that are included in wildlife resources. And so I don't think it automatically defaults to minimize and mitigate if you can't entirely avoid every single potential impact to wildlife resources as you apply the mitigation hierarchy. I don't think that was intended when the rule was developed, and I don't think that's the way that I would interpret that rule. And so, as I had indicated, I do think that there is a pretty clear application of the avoid, minimize, and mitigation hierarchy. I don't think that that means that it only gets applied to avoid high priority habitat. There's certainly opportunities to avoid adverse impacts to wildlife resources even outside of high priority habitat as you're looking at how to be protective as we're reviewing applications. But that's not here nor there, because I do believe that, you know, we made the correct decision in the initial application of this. I'm just going to defer my comments to the comments of Commissioner Ackerman, because I agree wholeheartedly with the thorough analysis that he provided. And so I don't feel like I need to go into any further detail on that. I will point out just one last thing, though, that while the pre-application processes that are included in our rules are critical, they don't supplant the authority of this commission in determining whether or not an application meets the rules and standards of the COGCC. And so the insinuation that just because there was a pre-application meeting where not at that point all of the information would necessarily be known by all of the parties, because I'm sure the application continues to evolve as it goes through the necessary processes of completeness determination and technical review before it even gets to us, that should be the basis for a decision on whether or not it meets the rules or the act. And so with that, I will just agree with the rest of my commissioners that this motion be denied.
Further discussion? Do we have a motion? Commissioner Ackerman?
Thank you, Mr. Chair. I move to deny the motion for reconsideration.
We have a
So-
motion. Do we have a second? Second from Commissioner Messner. Further discussion on the motion, which is to deny the application. A yes vote would be to deny the application. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? The motion is denied. Ms. Wazalicki, we do appreciate your professionalism and your presentation this afternoon. I believe this concludes the business before the agenda, before the commission today. Does anyone have anything further? Seeing none, I'm looking for a motion to adjourn.
So moved.
Motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? The business of the Colorado Oil and Gas Commission is adjourned for the day.